Good morning, everyone. Hope you had a great week. Good morning, everyone. There we go. Great way to start a Monday morning. We're going to start it off this morning with, we cut that down just a hair. We're going to start this morning with Senate Bill 100 for members of the committee that will be presented by former House member and Senator Buddy Carter. Senator Carter, thank you for being with us this morning. There's fine. Thank you.
Thank you, Mr. Chairman, members of the committee. I bring before you today Senate Bill 100. Senate Bill 100 simply adds a fifth option for nursing school programs in a four-year nonprofit schools. It adds it to the Georgia Registered Nurse Practitioner Act.
All right, I like those kind of presentations, and I don't see any questions from members of the committee. Representative Wilkerson, I will at this time recognize you.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, with Senator Carter's approval, I'm offering Amendment AM 331096. It's in your folders.
All right, thank you so much for that presentation. That has, for the members of the benefit of the members of the committee, which has the blessing of Senator Seabaugh, who this bill actually belongs to. This is an amendment offered by the chairwoman, Ms. Cooper, and we've got a motion on the floor to accept it. Do I hear a second? All those in favor signify by saying aye. Any discussion? Anybody opposed? Thank you. Now I'm making a motion. I'll entertain a motion. The chair will entertain a motion on passage of Senate Bill 100 as amended. Got a motion. I hear a second. All those in favor signify by saying aye. Any opposed? Congratulations. Thank you for a great presentation. And my dear, dear friend and abled chairwoman of Natural Resources, Chairwoman Smith, will present Senate Bill 211.
Thank you. Good morning, Mr. Chairman, members of the committee. I have before you what is Senate Bill 211 by Senator Ross Tolleson. This bill has a history on the Senate side of going to Natural Resources and Environment, and on the House side it's been to Children and Youth, and now it's at Health and Human Services. And so let me briefly explain what it does. It was House Bill 502 that made it to rules. It came from Children and Youth, but this is Senate Bill 211, which did cross over. This bill reenacts provisions of former Code Section 31316, which was repealed by Senate Bill 78 on May 27, 2010. This bill adds a new section, the Chapter 41 of Title 31 of OCGA. This bill makes it unlawful to engage in lead-based paint activities, and it provides for certain federal regulations, license fees, corrective orders, and violations. This act becomes effective upon the governor's approval, and any and all parts of laws conflict are repealed. This bill essentially restores language that was lost during the legislative process of 2010. This bill restores that language, which has been lost since 1994. What happened is there was not a strike-through on the language, which is what we as legislators know to look for when language is changed. This section just disappeared. Do not ask me how that happened, but when our legislative council wrote our code section, it was left out. So this is essentially restoring something that's been in place since 1994. Basically, EPD is the agent of record for EPA, and we enforce the rules that are passed by the federal government. If we fail to do so, then the EPA becomes our enforcer and regulator of this act. And the act became stricter a few years ago with the federal government. It now deals with lead-based dust in addition to paint chips, which is why it's had a history of being in Children and Youth, and also why I look at it, because I deal with EPD. Thank you, Mr. Chairman.
Thank you for that fine presentation. Any questions of the presenter of the bill from the committee? Anyone else like to speak in regards to this bill? Representative Harden, I recognize you. Got a motion due passed. I hear a second. Any discussion? All those in favor signify by saying aye. Opposed, like sign.
Thank you, Mr. Chairman,
Congratulations.
members of the committee.
This time the chair will recognize our good friend that does a great job representing Middle Georgia, Representative David Lucas, to hear House Resolution 757.
Thank you, Mr. Chairman and members of the committee. House Resolution 757, basis study committee to study the actuarial soundness of our health benefit plan. As many of you know, we have been receiving increased costs as well as on your copay too. And we have 700,000 state employees under health insurance, and we've been dealing with whether or not we have enough in our reserve to deal with. And this study committee comes about with some help from Representative Harden and Parrish as well as Stevens on meeting with the folks who handle our health insurance and really not being able to get a real good answer as to what happens with prior approval of the formulary as they have changed it and what it's costing state employees.
Any questions from members of the committee? At this time, the chair will entertain a motion. Motion do pass. Do I hear a second? Any discussion? All those in favor signify by saying aye. Opposed, like sign. Thank you, Representative Lucas. House passed Resolution 757 out of committee. Zipping right through this. Yes. Easy. You have a bill? Is Representative Sims here? The committee's gonna sit in recess for just a few minutes. Thank you. Thank you, members of the committee. We've got thank you, members of the committee, for allowing the short recess. We've got a Senate Rules Committee going on, which is causing us a little communication situation. So at this time, the committee will hear Senate Bill 135 being presented by Chairman Wilkinson.
Thank you, Mr. Chairman, fellow members of the committee. Presenting Senate Bill 135. This prohibits anyone but a doctor of chiropractic from rendering chiropractic services or chiropractic adjustments. It makes very clear that the law does not prohibit any practitioner from practicing within the scope of that person's license, people who do other such activities. The reason for this legislation is because there have been a few people outside chiropractic who have been advertising that they do chiropractic services and chiropractic adjustments. You know, Mr. Chairman, we've seen this in other fields where we've had to come in, and if I may quote Robert Frost, good fences make good neighbors, and this is exactly what we're doing. We're making certain that everyone understands where the property line is. Be glad to answer any questions.
And to quote the great South Georgia philosopher Booker Kinsey, you ain't lying. We're going to...
He's next to Robert Frost.
Right, yes. Well, that's the way we look at it.
And, Mr. Chairman, I understand that there is an amendment which is just basically to make this even stronger, clarify it even better, and I have no problem with that.
Right. Thank you so much.
Thank
Any
you.
questions for the presenter of the bill? All right. At this time, if you would, I'll hear your amendment.
Yes, sir. If I may invite the committee's attention to line 3, chiropractic services, comma, we would add chiropractic adjustments, chiropractic in front of adjustments, and then chiropractic in front of manipulations.
All right, make sure the language is a little tighter.
Yes, sir.
The chair will entertain a motion on the amendment. That's in line 3. we've been advised just in the preamble. Chair will entertain a motion to accept the amendment. Our second. All those in favor signify by saying aye. Those opposed, like sign. Thank you. Yes.
Why would we not want to change it in the middle of the bill?
That's the way we've been advised, and that any additional work that needs to be done will be done at a later time. But thank you for the question. Now the chair will entertain a motion on the Senate bill as amended. There's a second. Any discussion? All those in favor signify by saying aye. Those opposed, like sign. Thank you.
Thank you, Mr. Chairman, members of the committee.
Senate Bill 135 passes as amended. Is there anyone here to present Senate Bill 187? Senator Carter, you're recognized to present Senate Bill 66.
Thank you, Mr. Chairman, members of the committee. I bring before you today the Senate Bill 66. Senate Bill 66 has to do with perfusionists. For those of you who may not be aware, perfusionists are those medical professionals who operate the machinery that treats blood outside of the body. This is actually the machinery that you may see in place if you're having an open heart transplant. This perfusionists are required to be there to operate this machinery so that they can take care of the blood while it's outside of the body. This bill actually does three things. First of all, it defines the continuing education requirements for perfusionists. You will find that on line, you'll find that on page 2 on line 31. That is the continuing education requirements. Starting on page 2, line 47, you'll see the updating of the definitions of practice. We strike some, and then starting on line 73, we add more to it. And then finally, it also redefines the licensing renewal requirements for this profession, and that's found on page 4 on line 118. And that's essentially what this bill does, Mr. Chairman.
Thank you so much. Any questions from members of the committee for the senator? At this time, the chair will entertain a motion. Motion, do we have a second? Any discussion? All those in favor signify by saying aye. Any opposed, like sign. Congratulations, Senate Bill 66 passes.
Thank you, Mr. Chairman, members of the committee.
All right, do we have anybody here to present Senate Bill 187? Anybody here to present Senate Bill 76? Anyone here to present Senate Bill 183? All right, at this time I ask the committee to be in recess.
Okay, let's call the meeting back to order. We're going to, Senator Carter has been nice enough to say that he would present a couple of the bills, and then one of the senators is on his way. Senator Carter, you want to start with Senate Bill 76? That's the Georgia Trauma Care Network Commission.
Thank you, Madam Chair. Members of the committee, I bring before you today Senate Bill 76. This was authored by Senator Mullis up in extreme northwest Georgia. What this bill does is to allow the Trauma Commission to reimburse EMS services in Georgia for transporting Georgia patients to out-of-state trauma centers. As you know, some of our border counties, it's much more practical, especially in that area in northwest Georgia, to utilize the trauma center in Chattanooga. And what we're simply trying to do is to allow the Trauma Commission to reimburse for EMS services to carry those patients to those trauma centers. That is found on LC 334194S on line 66. That's on page 3. It just simply says in the ad, and to trauma patients transported to out-of-state hospitals is approved by the Commission. There is another portion of it, Madam Chair, that I would ask for assistance on, and
Okay, that'd be fine.
if that's okay.
Hi, members of the committee. I'm Josh Mackey. I'm representing the Georgia Association of EMS. We're actually supporting both pieces included in the substitute. But sections 1 and 2 in the bill of the bill are from HB 247, which simply allows the State Office of EMS to receive national criminal background checks from the FBI. This is done for nurses, firefighters, daycare workers. It's pretty standard language coming from the FBI. Currently, they have to do a background check that's submitted each time they want to, or when they want to become initially licensed. And all this is allowing them to receive it directly rather than submitting it.
Questions for the senator or for Josh? Okay. You got it?
Thank you, Madam Chairman. I don't know who the best person is to answer these two questions. But one question is, from the standpoint, does the Trauma Commission have the authority to, in essence, buy an ambulance for an ambulance service in a quote-unquote underserved area?
Yes.
Yes, what they do is they do a vehicle replacement grant, and they actually, in the past, they've given a grant in underserved areas for the service to go out and purchase a replacement ambulance. Usually what it is it's about 75% of the funds come from the grant, and then the actual local service puts up about a quarter of the funds.
Follow up to that question, if I may.
Sure.
If the state of Georgia is giving $100,000 to a private ambulance provider to offset some of the cost of an ambulance, does that ambulance provider give a discounted rate to the state when it's carrying people? Or are they charging full bore and the state's just giving somebody part of an asset?
I'm not positive on that. I'm not sure I can answer that question. The only scenarios I've been familiar when a private ambulance service, particularly in a rural area, does get one of those vehicle replacement grants, the only scenarios I'm familiar with are they do possess the ambulance, but that is titled to the county that actually has the 911 zone.
Well, I asked a question. The best question some people ask when they know the answer themselves before they ask the question, which I do in that case, is that the state's given the $100,000 to a private entity for the purpose of purchasing an ambulance, and the state's getting nothing in return other than an ambulance being in a rural area to pick up somebody. But the state is just basically giving an asset to somebody. Second question. Recently, an individual was transported by air ambulance 100 miles round trip. Let's say it's 100 miles one way and 100 miles to the facility. Mm-hmm. And the air ambulance service billed that round trip 100 miles at $28,000. Would the state be reimbursing that air ambulance to the tune of $28,000 for a 200-mile trip?
No, they wouldn't. Currently, the Trauma Commission does not provide reimbursements to any air ambulance services. They could in the future, but air ambulance services haven't actually had any state regulations until I think they went into effect in December, and they're going to go fully into effect this July. So right now, the Trauma Commission doesn't reimburse any air ambulance service.
Who would this individual complain to for $28,000 charge for a 2-hour flight?
Probably the Department of Community Health.
Thank you.
Okay. Other questions for Josh or the senator? Okay. Okay. And I will tell you, Representative Kidd, I think so the committee will have the facts. Wasn't that where they gave them the grant for the ambulances in a very rural area where economically, if they had not gotten assistance, that they would have stopped their service?
I'm not sure. I talked to the provider about it a month or so ago because I raised this question a year ago in another committee meeting.
Okay.
And the individual who got, yes, I did talk to him about it, but I just wanted for the record to ask a question.
Okay. I think we need to find out. It was my understanding that it was an extreme case, and in trying to get coverage for the state, it was in an area where we were just not going to have any coverage unless they got some assistance with being able to pick people up after traumatic events. But we'll see if we can get you another. Josh, could you ask the doctor that runs the trauma system to get that information for us?
I'll speak with Dr. Ashley.
Okay. Thank you very much for that. Representative Watson, you're recognized.
I'd like to make a motion that we accept this and move this bill for a vote.
Okay, we have a motion to do pass. Do I have a second? Is there any? We have a motion and a second. Is there any further discussion? Okay, seeing and hearing no further discussion, everyone in favor say aye. Aye. Anyone opposed, no. Looks like the ayes have it. Senator, you're on again. Thank you very much for being here.
Thank you. Thank you, Madam Chair, members of the committee. I bring before you today Senate Bill 183. Senate Bill 183 has to do with the school nurses and simply allows local boards of education to consult with off-campus healthcare professionals using appropriate protocols and contracts for the school nurse program. You'll see I'm reading off of LC 334090 on line 13. Well, let's start on line 12. It says, such school health nurse programs shall be staffed by licensed healthcare professionals and may include consultation with off-site healthcare professionals through appropriate protocols and contracts.
Pardon, Representative Kidd? I think that's what this is written for, Representative Kidd,
yes.
Being you're astute, is that they can use telemedicine to take care of the students. Doesn't say it. Seems like it should have said it somewhere in there,
yeah.
but it is a roundabout way. Any other questions? Questions for the senator? No questions? All right. What's the? Okay, we have a motion to pass. We got a second. Any further discussion? Everyone in favor of the passage of Senate Bill, which one are we on? With Senate Bill 183, say aye. Aye. Anyone opposed, no. Okay, the ayes have it. Okay, we are standing down again for a minute. House Bill 187.
Thank you, Madam Chair. I'm here today to speak to Senate Bill 187, which is a bill that would reform licensing requirements to become a registered nurse in Georgia. Just give you a little background. Up until 2008, graduates of non-traditional nursing programs were able to become licensed as registered nurses in Georgia through endorsement. If they were licensed in another state, they simply waived into Georgia. There was a change in the law in 2008, which at the time was advertised as administrative cleanup, but in fact, when interpreted by the Board of Nursing, closed Georgia to graduates from non-traditional education programs. And there have been...
I don't know who's giving your information about a cleanup, but that information was presented on the House floor. We pulled the record of that presentation on the floor. At no time was it made as this presentation of a cleanup, and it was said that we were going to start requiring the same thing of all our schools. So just to set the record straight, it was never presented in that manner. I think somebody has given you the wrong information.
Okay.
Proceed.
My understanding is that it was not explained at the time that it would close off Georgia to non-traditional nursing programs. What we seek to do with Senate Bill 182 is basically try to move the pendulum back kind of in the middle in an area where we think there's a good compromise between certainly protecting the public, but also making sure that the licensing requirements are reasonable. And what we essentially do are create two tiers for or pathways for graduates of non-traditional programs to become licensed RNs in Georgia. For military medical corpsmen, paramedics, or LPNs who have over a year of experience, who complete the non-traditional education program, and who pass the licensing exam, those students would be licensed upon completion of those requirements. For military medical corpsmen, paramedics, and LPNs with less than 1 year of experience, they would, upon review by the Board of Nursing, be subject to a preceptorship. And we feel that Senate Bill 187 allows us to address the critical nursing shortage that's facing this state without penalizing individuals who have had experience in the nursing field, but simply go through a non-traditional education curriculum after passing the licensing exam and meeting all other requirements under state law. And that is, in essence, the effect and design of Senate Bill 187. I'd be happy to answer any questions.
Okay. Questions for the senators? Representative Reiners. Is that, do you have a, oh, Representative Kidd.
Thank you, Madam Chairman. I guess this is my question day. I must have got a lot of sleep last week on our break. I know in the practice of medicine, medical doctors, there was for years, there was a fifth pathway. They called it a fifth pathway to get a license to practice in Georgia. And for years and years, the legislature voted down approving a fifth pathway to get a medical license. Are you familiar with what that is by chance?
No, sir, I'm not.
All right, the fifth pathway was through Guadalajara or through foreign medical schools. Are you referring to a similar type thing for nurses and so forth? There's a fifth pathway type approach from foreign medical schools or schools in Mexico or Taiwan or wherever they might be?
There are requirements in the bill for what a non-traditional nursing education program would consist of, and it certainly, and I'm not pretending that it is the same as a traditional nursing educational program. The difference, which we think is a critical difference, is the experience that these folks have had, whether it's been serving as an Army medic or a paramedic or an LPN. And again, we feel like prior to 2008, it was just sort of wide open. If you qualified in Alabama, you could come right in and be an RN in Georgia. This establishes a middle position Where we're not doing that, we're not letting everybody come in that meets the requirements in any of the other 50 states. We're making them meet additional requirements, but we're doing so in a way that doesn't penalize someone who's had thousands of hours of experience that's then being asked to be subjected to a preceptorship on top of that. And for those that have less than a year of experience, we're leaving that totally up to the Board of Nursing to make that decision.
Follow up, Madam Chairman.
Yes.
Is not this legislation as written a lot broader than just a mechanism by which military nurses can get licensed in Georgia? I'm all for rewarding our military personnel who are in MASH units and so forth, and seeing all the and treating. But isn't this a lot broader than just that?
It is certainly broader than just military personnel.
That's
yes,
what I
sir.
thought. Thank you, sir.
Okay. Other questions? Okay. Representative Trocas.
Thank you, Senator. I see in the legislation where currently it requires for a non-traditional nursing education program as a licensed practical nurse with at least 3 years of clinical experience in the healthcare facility as a licensed practical nurse. And if I'm not mistaken, you're changing that to 1 year?
That's correct. Yes, sir.
All right. And just a moment ago, you said thousands of hours. If they worked 40 hours, 2,000 in 1 year. I wanted to make sure that that was accurate. Do you think that 1 year experience is enough?
Yes, sir. I wouldn't have brought the bill if I didn't feel that 1 year of experience was sufficient.
Thank you.
Okay. Representative Kaiser.
Thank you, Madam Chairwoman. Senator, I, with Representative Kidd, I really strongly agree with the clinical experience that our military have and what they bring to the table. But would you talk just a little bit about the clinical experience that is received on the job? I guess I'm thinking of an example, a nurse in a hospital setting who that's the kind of work that they'll be doing going forward. So in a nursing situation in a hospital, they're trained a little bit differently than the broader aspect of the population you're talking about here. So, for example, somebody who has a post-operative procedure who should have leg, leg, what is that called? Oh. The tight things on their legs to keep the compression, to prevent a blood clot. I mean, that's very specific training that might not necessarily occur if you shorten the time frame within which they get the clinical experience. So just, if you could address kind of, and also, for me, I get concerned about the hands-on experience because the recognition when someone shouldn't be discharged after a 24-hour procedure, that's something, sometimes it takes a little more time clinically to recognize this post-op types of situations. So if you would just talk that a little bit.
Well, I think that basically the system that we would be setting up under Senate Bill 187, for those that don't have very much clinical experience, obviously we're leaving that to the Board of Nursing to decide whether or not someone with less than a year of experience should be just licensed immediately without a preceptorship. And I think it's correct that they be given the discretion to make that call. Once we have someone they've had a year of experience, they have completed the non-traditional program, they have passed the licensing exam, at that point, I certainly feel that person has met the requirements that they need to meet to move forward. Now, how the hospitals choose to integrate any new employee or new registered nurse, I think certainly there would probably be training offered if they were looking to put them in a specialty area, and we're just giving the healthcare provider the discretion to do that rather than sort of imposing a one-size-fits-all type formula. So I think that's really what we're doing here, is offering some additional flexibility.
Senator, I have a couple of questions for you. Can you define healthcare facility?
I don't have.
This is where you're saying that in a healthcare facility, a year's healthcare. We have legal counsel. You want me to have her read the definition?
Right. I don't have the bill in front of me, but I know the bill defines healthcare facility.
Tell us what healthcare facility includes.
Well, it's not defined for purposes of this code section, so it would be up to the board to define that, basically.
Okay, but in the code section where healthcare facility, does it not include home health care, a podiatrist office?
It does, but not for purposes of this code section. Other places in the code that would apply to this that would be brought
Right,
up.
but that, okay. And Senator, can you tell me the difference between, you are saying that if a graduate has 1 year's experience as an LPN, not as an RN, but as an LPN, okay, can you tell me the difference between the education and what RNs learn and what an LPN learns?
Again, I don't have that in front of me, but I think what we're trying to do is, again, to create a balance between the system that existed under the law prior to 2008, which was wide open, and the current law, which is, at least in my opinion, overly restrictive. And I think that these three categories have been singled out in prior law, and we're adjusting some time frames and where the Board of Nursing has discretion to make those decisions about whether or not additional training is required.
Well, Senator, just to let the committee know, before, when you're talking about that the law was wide open, the board and Excelsior came, this is about Excelsior School, even though it is not written as an Excelsior bill, kept coming down and meeting with our Board of Nursing, and our Board of Nursing would not let Excelsior graduates sit for the board in the state of Georgia because they did not have clinical training while they were in the program. And there was ongoing discussions, and there was a loophole in the law that allowed them to go across state lines and take the board and come back in. And that's what was changed in 80. So it wasn't totally wide open. Our board for many years said that they did not feel that the program met the standards of the programs that we have in Georgia. So just a little background on that, because there were many meetings, and they are documented, between the Board of Nursing and Excelsior in trying to let the students take the boards, and they were not allowed to do that. Okay, further questions? Who have I got? Representative Morgan. Excuse me. Let me go.
Thank you, Madam Chair. Good morning, Senator.
Good morning.
Just a couple of questions. As you talked about the Board of Nursing being able to make a decision based on an individual candidate. So if you could talk about what that process would look like. One of my concerns as you talk about the board being able to have this discretion really is the standard that would be applied. And I don't know if you could answer this or someone else, maybe what is the current practice if a nurse wants to appeal a decision that the Board of Nursing has made, and in this case it would be whether or not they need to have a preceptorship, what would be their recourse? So if you could talk me through that process and what that would look like if a nurse came and wanted to bypass his preceptorship, what that process would look like, and then if they did not agree with the decision, what recourse they would have.
Yeah, I would probably have to defer to the Board of Nursing on their internal procedures. I know under current law, the folks that we're trying to deal with this bill are going to be required to perform these preceptorships, and what we're trying to do again is to kind of separate out and say, here's a group that we think may need some additional training, and so we'll leave that up to the Board of Nursing to decide. But once they get beyond 1 year, they ought to be licensed. But as far as an internal process that the Board of Nursing has to deal with grievances or appeals, I'm not familiar with that.
Could you go a step back then, before you get to the appeal process? What would you see as a process that you would be comfortable with for them to look at a candidate that would have less than a year's time to decide that they don't need a preceptorship? What does that look like for you?
I think they would have to review the individual applicant's clinical experience during that period of time. A couple of the questions have touched on folks with a military background versus some of the other categories that are dealt with in the bill. I think certainly someone who had seen a 6-month tour in a forward area and had done an awful lot of Army medic work during that time, that the board might take one view of an applicant with that kind of experience, but another of someone who had not had that sort of intense experience over that short time frame.
One more question, Madam Chair, if I can. I'm having a hard time, so I want you to help me to understand, because I'm thinking if someone has 6 months experience in the military, you know, in a very intense, stressful, you know, environment versus working in a hospital, even in an emergency room, those are two very different things. So I'm wondering if I took my child, or if I went to an emergency room and needed care, if someone who had 6 months experience in the military is really, does that really qualify them to know how to deal with just a typical situation in an emergency room?
Well, and I think that's why, you know, for that period of less than 12 months experience, we want the Board of Nursing to make that call. We want them to review each individual applicant, treat them on their own merits, and see if that is something that is up to the standard so that they can make that decision. We don't think we should be codifying that. We think that they should have the discretion within that time frame to make that kind of decision.
Thank you.
Other questions? So, Representative Reinders.
She's got me thinking about this process now a little bit. You know, everything is subjective and welcome. You know, if I'm a nurse in the Navy on a ship and I do 3 months, Corpsman, thank you, and I do 3 months, do you say that is more or less valuable in terms of its training than someone who is in a combat zone for 2 weeks?
I mean, I think, again, that would ultimately be, you know, a decision for the Board of Nursing if we're talking about the folks within that 12-month period. I think if we go beyond that period and you say, well, what about 1 year, what about 2 years, what about 3 years? Well, I can tell you, you know, I went through 3 years of law school and passed a bar exam. I don't think I was qualified at that time to try a capital murder case. So at some point, we have to recognize that people who are newly minted in any profession are going to receive training that their employer wants them to have so that they can perform what functions they want them to perform. I think the question is, where do we draw that line to where we believe that someone is ready and has at least achieved a baseline of skills to be able to go forward? And I think that's what this bill does. It gets that person to that baseline.
May I continue, Madam Chair?
Yes.
Did you say you're an attorney?
Yes, sir.
So do you think that there should be any other circumstances that the Board of Nursing should take into consideration? Hypothetically, of course, if, for example, we know that the nurse was applying to an underserved area and they only had 2 weeks of training, but since there was that shortage in that underserved area, maybe we'll give them the nod that we didn't give the previous applicant with just the same amount of experience a month earlier because they were being served in a more metropolitan area, perhaps where the shortage wasn't as great. Should they take those kind of factors into consideration?
I don't believe so. I mean, I think it would be up to the Board of Nursing to establish their criteria. I think if we did that, ultimately what we would be doing is, you know, basing the type of health care, the quality of health care someone's going to receive on where in the state that they live. And so I would have some concern about that.
So you don't think there should be any other factors considered?
Well, I'm not saying there shouldn't be any other factors considered. I think that the Board of Nursing is going to have to establish a criteria by which they're going to decide that for those folks that fall within that 12-month window, whether or not they should be a licensed registered nurse if they've met all the other requirements.
Have you asked them what the other criteria might be?
I have not had that discussion with them. No,
Do you
sir.
think the 2 weeks matters in combat versus not, or an underserved area would matter? I'd be scared to give somebody that kind of blanket responsibility when my constituents would be the ones that would hold me accountable. That's what I'm wondering.
Well, I think, again, when we're talking about licensing of any profession, ultimately we are placing faith in the regulator that we're going to get a good quality product. So I think, again, vesting them with that discretion is simply an attempt to do that. And I agree with you. There's some criteria we would not want out there, but I think if we get to the point where we can codify it to the point where there's really no flexibility at all for them to make those determinations.
Thank you, Madam Chair.
Okay. Senator, do you think that there's, here again back, do you think that there's no difference between an LPN that goes 1 year and an RN that goes either 2 or 4 years? And not a difference in a body of knowledge?
I think that both of those individuals have passed the licensing examination, and I think both of those individuals have had significant clinical experience, and that between that and the educational program they've completed and the experience they've had, that at that point they should be allowed to be a registered nurse.
Okay. All right. So you're saying that if they've had a year's practical experience as a nurse, there's no difference in that in their education, basically. And what I guess I want to be a little humorous here, but would you bring a bill next year that allows paralegals who go to school to do the same thing that this bill does, allow them to take a few college credits, have a 2.5-day checkoff list, and then pass your bar and then become practicing attorneys?
I would not have a problem at all with anyone that wanted to sit for the state bar exam who passed it being licensed to practice law. Well, and that's what the state of California and many other states do. If you pass the multi-state bar examination at a certain level, the state of Michigan lets you in. When I took the bar examination in Georgia, Alabama accepted part of that exam. I had to complete another written portion. But I think that absolutely, that if someone is able to meet the licensing exam, if they're able to pass it, the bar exam in your example, then I think they are absolutely entitled to be able to receive a license to practice.
Of course, there's a little difference. Unless you do law that deals with the death penalty, you're not dealing with life and death situations, are you? And when somebody gets a nurse's license, it doesn't say, like, if they've been a paramedic and they've been in the combat zone for 6 months and gone to this school, that they only work in the emergency room. It allows them to work in a neonatal unit or pediatrics and to do, or any of the areas that cover nursing, and many of them are life and death situations. So I think they're different. Further questions for the Senator? Okay, here we go. Representative Hatchett.
The Board of Nursing, is it a board that constantly meets, or is there full-time people that would be making these decisions, or is it actually the board that would be meeting to make all these decisions or exceptions? And
I believe the Board of Nursing meets on a periodic basis. They're not full-time employees of the state or anything like that.
Okay. Thank you.
They meet about every 2 months, and then they have phone meetings, but I think they meet together about every 2 months. So, further questions? Okay. Seeing no further questions, thank you, Senator.
Thank you.
Do you have a question? Okay. Okay, what's the pleasure of the committee? Representative Kidd.
Madam Chair, in light that there is not a motion due pass on this legislation at this time, considering the amount of questions and concerns a lot of people had, I would much rather see the legislation be split up and be brought back, one addressing military personnel, another aspect, another bill addressing the other aspects. So in light of that, I'd like to make a motion this time do not pass.
Okay, we have a motion to do not pass. Do we have a second? Second. Got a motion to do not pass and a second. Any discussion? Okay, everyone in favor of do not pass, say aye.
Aye.
Anyone opposed? No. No. The bill fails. Thank you. Is that it? We got everything? Thank you very much, committee members, for